Right here's your first big twist before we even dive in. Notice how unsure the defendant sounds. Moments like these usually hint at confusion, nerves, or someone who knows the situation is about to get complicated. Keep watching. This bond discussion quickly turns into a full legal tug of war.
It's Tyron, whatever you'd like.
So we can, maybe we
I don't know
can.
about a bond is because it's kind of.
Yeah, no,
It's a free time.
we don't want.
Oh, got it.
And maybe we can review PC. I think we're in agreement with the trespass. There was no trespass for the.
I'm always happy to hear PC. Let's do it.
Yeah.
Dave, you want to do it or no?
Let's do it.
Okay.
All right.
What's the contract reference?
255-4294.
It's on document.
Oh, it is?
Yeah.
Sorry.
Yes.
Okay. On March 4th, 2025, at approximately 10:30 a.m., officers were conducting an investigation for an evading case at Oyo Hotel. The officer made contact with the manager of the hotel, who showed surveillance video that showed a male who had been given several trespass warnings and stated he refused to leave and comes back all the time. The suspect was a black male with a jean jacket and dreads. There is also a posted no trespassing affidavit on the front of the hotel. The officer spotted the male and attempted to make contact with him. The officer approached the defendant and the defendant began walking away, and the officer advised him to stop. The officer placed his hand on the defendant's arm and the defendant began running down the stairs carrying his bicycle. While running, the defendant used his bicycle as a barrier and shoved it towards the officer, hitting his left knee. The defendant continued to run around the motel, and he grabbed his bicycle, which he left on the left side of the building, and the officer was able to take the defendant into custody after a taser was used. The defendant was identified by his Georgia ID card. The defendant has an open probation violation warrant out of Louisiana for a weapons charge.
So he's at a hotel.
Yes,
Was he, you're saying he's not allowed to be there.
correct.
Are you saying he was?
There's no trespass warrant on file with his name on it. I believe there's
This is where things get legally spicy. The defense is arguing there's no individualized trespass affidavit, which means the whole case risks collapsing if the warnings weren't specific, verified, or properly documented. This is a classic courtroom moment. The state says verbal warnings count. The defense says not without proof, and the judge is stuck in the middle trying to decide what actually holds up. What do you think? Should a generic hotel affidavit be enough?
there's a homeless encampment near this hotel, off Highway 6. And so a lot of the homeless people go back and forth. Mr. McGee is homeless. I don't know. It's not clear whether Mr. McGee is the person that they're referring to. I know he's a black male with dreads, but he's never received a trespass affidavit. And there's no information of that.
You said that there was one.
It says in the DIMS that the complainant pointed out the defendant on surveillance video and said, I have told him several times, I've given him several trespass warnings and he refuses to leave and he comes back all the time. And then also it
Maybe
is
they were
stated in the
verbal.
DIMS that there's a trespass affidavit posted on the front of the hotel.
Okay, but that doesn't mean anything. That just means like no trespassing.
And usually with
It's
the
like,
trespass affidavits, he was there visiting someone that stays there. So in all of the loitering with convenience stores and things of that nature, that applies to people that are there without any kind of, if you're not buying anything, visiting anyone. So he was visiting one of the people that was staying there. That's why he had his bicycle. The police, I basically just grabbed him and he was coming down the stairs. So I don't think we have a valid trespassing case because there's no affidavit with his name on it. And if he was there legally visiting someone at the hotel.
is a verbal trespass warning sufficient?
I would disagree, Your Honor, especially because this is, and I guess we would need to see what their trespass affidavit says, because usually the ones at the convenience stores, I've dealt with this a lot, it excludes people that are there legally.
I mean, I get that the penal code doesn't say that it has to be in writing though. You know, I mean, it could say, hey, I don't want you here. Don't come here anymore. So,
But then if we take that lengthy, that there's a trespass affidavit, then that means.
But then anybody could say,
That's correct.
good, I get it, I get it.
Go in and visit my aunt, and she was staying at that hotel, so it can't be that restricted. If he was there with his bicycle, he wasn't just out in the front visiting someone, he was up inside of the hotel with his bicycle coming down, he was there visiting someone. So I don't think that there's any information or evidence that says that.
So the state would concede that a general trespass affidavit would not be enough. So it would be due to the verbal trespass warnings that were given to him several times by the manager and him refusing to leave the location.
So where do we go from here? Like, how are we gonna?
My goal is, Judge, or my hope is that the state, in looking at this and knowing that he has a case out of New Orleans, which he's on parole on, I'm hoping that they will resolve these issues. I have spoken with his parole officer, and bond or not, he is going to have to sit in jail another 14 days to be extradited. But because he's on parole, I cannot plead to anything because I want him to get to New Orleans and have the ability to potentially get terminated.
They're coming, we'll see, right?
They are,
But it's Louisiana, so they should be here.
it'll be pretty fast.
I mean,
The larger part of it's not Louisiana jail, it's not the Richardson Parish jail, this is a parole violation. I think what council is saying is that for whatever they condemn for the parole violation, they're gonna have it before the board. It'll obviously, it takes a conviction that's gonna affect his eligibility versus a dismissal.
But there was already a warrant regardless.
Right.
Something happened regardless of perhaps he absconded or.
Because he had been here homeless off the grid, so because he had no residence and things like that. And so that's why, but for conviction here.
Right. The only problem, Ms. Sparks, is that the 14 days or any time it's told,
As long as this is going on.
because he's not made, you know.
Yeah,
One of them, I think one of them should be bought.
I'm showing both their,
yeah, no,
he's not made bond on
we
either.
were
of them.
told it made no sense to me.
If I may, last Friday, we revoked the bond on the local.
And here comes the emotional powerhouse moment. The judge finally snaps. When a judge switches from procedural discussion to a direct moral warning, it means they've reached their limit. This isn't just legal anymore, it's personal. Notice how he stacks the defendant's history, the risks, the community safety concerns. This is the judge trying one last time to shake someone away.
He's speaking Louisiana from coming to get him.
Oh,
So that's this one?
I don't
Yes.
remember. I didn't remember that. I thought it was someone else that we.
Yeah.
Okay, so,
So that way he wouldn't have to go back and forth and deal with the
right,
same.
you're right. No, she's right, because the problem is that if they come and get him, he goes over there, then a hold gets placed on the exact same situation, so.
I trust Blaze, and his staff.
Guys,
Stand down.
whatever you want to do, if you want to set it maybe just a couple days to look further to see if there is anything, if you could probably perhaps somehow get that he's actually visiting someone,
Yes, Your
you
Honor.
know.
Okay, yes, Your Honor, I'll stand down. Thank you.
Thank you, Judge.
You know, Mr. Flores, I really don't know what it's going to take to get your attention that we're not going to stand for anyone endangering our public. Really. I mean, you've had in the last 3 years, 3 very serious cases, and now you're picking up a DWI. All of them are dangerous cases. What's it going to take? A 25-year sentence? Is that what it's going to take to get you to realize, you know, all the stuff here is things that if you just think, they don't have to happen. All the time, all the money, all the just that you spend coming here can all be avoided by not using. You know what I mean? That's all it takes. From now on, what we're doing today, you're now facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? There are more proverbial slaps on the wrist. What you're pleading to now is a DWI. This DWI will go on your record. It will be there for the rest of your life. You can never take it off. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this case, like I said, it'll go on your record. You can never take it off. Do you understand?
Yes, Your Honor.
You know, the other thing is this, is that your lawyer is asking to waive all the fines and fees. If you ever pick up another DWI, it is a $6,000 surcharge that you will be required to pay. And if you don't pay it, you sit 1 day for every $100 you owe. If you want to get lit, 52 beers, 32 shots of tequila, take a freaking Uber. $40 wherever you want to go in this damn city. Don't kill anyone. How do you plead to the DWI? Guilty or not guilty?
Yeah.
I'm going to find you guilty and I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 180 days. Don't get into a car. Driving on a suspended license case is just like a DWI. You pick one up, you're going to be right back in here, and it's just not going to go well for you.
Yes, Your Honor.
You understand?
Yes.
All right, good luck.
Thank you, Judge.
I have, Mr. Escamilla and, Ms. Victoria says we need to approach you on the reset because you sent him for a drug test, Judge.
Positive for what?
THC, Judge.
No more. You are not allowed to use. It is a condition of your bond. I will give you up to 50 days, and I'm going to test you again. If I find that you continue to use, I will put you in jail. No more PR bonds for you.
Yes, sir.
You take off on me again, it's really not going to go well for you. Do you understand?
Yes, sir.
Okay, I put a GPS monitor on him and I've given him a curfew because he's taken off on us many, many times. His case is 1,000 days old. So I'll give you a reset, but I think that we were waiting on, is discovery complete on the assault case?
It says the only outstanding thing is, photos from the complainant.
Okay, if you can please
Yes.
get that.
Judge, just for the record, I was just appointed today. Okay.
No, I'll give you time.
Thank you. Thank
Sure. But I'm gonna test you like crazy.
Yes,
Just
sir.
get ready.
I'm working. Yes.
I'm gonna go, it's on your ball.
Yes, sir. Understand.
It's your responsibility to stay in touch with her too. If she tells me she can't get a hold of you because you're ducking and dodging, likewise.
Yes, sir.
Jail you will go.
Understand.
All right?
And,
Okay, Ms. Tucci.
Yes, Judge, we've had a long talk this morning
Good.
and he was really good about communicating earlier.
and,
Okay.
for my
Yes.
curfew, I work a night shift. I work 5 PM to 5 AM, so.
Judge, can it change to allow him to work?
I want proof. Show me proof. I'm not gonna take your word
All
for it.
right, but she'll send it to me and by Monday I'll bring it in and we'll adjust. Does he need to be here if you're going to adjust the curfew or can I just come show you?
Bring me legitimate proof and we can
And then we'll
talk.
talk.
And then, but remember, the GPS monitor tells me exactly where you go
Yes, sir.
at all times. So if you deviate,
Just worry about it. Yes, sir.
all right, okay.
I'll get the proof, Judge. Thank you so much.
Yes, ma'am.
All right, have a seat real quick.
Good morning, Mr. Goff. The reason that we took you into custody now is because you were on deferred for an aggravated assault of a family member. It looks like that's in warrant status now and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:50 PM, an officer observed a vehicle parked in a handicap parking space with no displayed license plate or placard and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted and 4 bags were located under the driver's seat, 0.154 ounces.
All right, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm going to find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm gonna appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or two to figure out what happens, okay? All right, man.